Welcome to the course Introduction to Urban Planning. In today's session, we are going to look at the legal requirements from the environmental point of view, and we'll mostly focus on the national level. And in this lecture, you should comprehend our planning objectives. At the same time, you should look at the environmental concerns which we are facing, which we have already covered before, and then other legislation in mind. You should keep those things in perspective while you go through this. And this is a very wide area, as we see that this is completely a subject in itself. So we are going to cover it in a very brief manner. So I'll just going to walk you through different legislations which are available to us, and I would say it's not a comprehensive list yet, but then we'll just review those in a very brief manner. So accordingly, our coverage for today would include that we'll look into the Environmental Protection Act of 1986, as well as we'll look at the National Environmental Policy, then EIA notification. To certain detail, we'll look at the Comprehensive Environmental Protection Index, as well as we'll look at the environmental quality concerns which are there and adopted in the system. We'll look at eco-sensitive zones. Further, we'll look at the coastal regulation zones, and then we'll also look at the e-waste management rules, then how we are moving forward to address the urban rivers, and then further we'll look into energy sector. Then we'll also briefly look into the Indian Forest Act. Further, we'll look at certain environmental guidelines which are important for us as urban planners, as well as we'll briefly just will name the guidelines which are available for us in disaster management. And then we'll look at the legal and regulatory framework for environmental protection. So that would be our coverage. Accordingly, the learning outcomes which is expected is that you should take a comprehensive review of all these acts, and you should be able to look at all these acts. You should be able to list them, you should be able to tell the purpose of these acts, and you should critically review in terms of what they are able to achieve or not achieve and what kind of provision they give. And you should be able to connect it with the larger goal of planning as well as larger sustainability development goals. So moving on and looking at Environmental Protection Act of 1986, we see as per the URDPFI guidelines, since we are looking at it from the perspective of planning, as per the URDPFI guidelines, there are certain norms and standards which should be referred for preparation of all the plans which we had seen for a city or whichever level we are preparing. So based on that, we should be looking at the rules identified in Environmental Protection Act of 1986, as well as we have certain standards like Air Act 1981, as well as Noise Pollution Regulation and Control Act of 2000. These all need to be referred. For the purpose of environmental clearance, the various statutory obligations for difference clearance are EIA notification of 2006, which should be referred by planners, as well as for the purpose of forest clearance, we look at Forest Conservation Act of 1980. Further, anything related with manufacture, use of import, export, storage of hazardous and genetically engineered organism or cells. For that, we look at the EPA Act of 1986 for GEAC clearance purpose. So let us first look into Environmental Protection Act of 1986. The Environmental Protection Act of 1986 has notified various rules under the environmental protection for protecting the environment related with manufacture, use, import, export and storage of hazardous substance, waste and so on, including municipal solid waste, noise pollution, ozone depletion, substance and likewise. You can see in the list here. The Environmental Protection Act of 1986 makes provision for the protection and improvement of the environment. This act was created at the backdrop of United Nations Conference on the Human Environment held at Stockholm in June 1972, in which India participated to take appropriate steps for the protection and improvement of human environment. Further, in 2006, we see National Environmental Policy. National Environmental Policy of 2006 covers an integrated approach to reduce the impact on environmental degradation on human life by taking proactive measures at various fronts. These include regulatory reform, process-related reforms, substantive reforms, enhancing and conserving environmental resources, prevention of land degradation, desert ecosystem, and also various other factors that influence the environment. This policy, we see that it focuses on ensuring that people who are dependent on natural resources for securing their livelihoods from the act of degradations should realize that a greater purpose will be served from the conservation of resources, which includes land, desert ecosystem, water, wildlife, forests, wetlands, and so on. Now, briefly and selectively, we will not look at all the aspects, selectively looking at the EIA notification of 2006. EIA, we have another subject on this, EIA, Environmental Impact Assessment. So, this was taken as a tool to take care of the sustainability aspect. So, EIA notification of 2006, we see that considering environmental concerns and to ensure that the economic growth and development in India is in conformity with regulations for environmental conservation, the Ministry of Environment and Forest and Climate Change notified the Environmental Impact Assessment notification in 2006. The EIA notification 2006 has notified the various developmental sectors which require prior environmental clearance. So, you can find a list which gives various sectors, activities and projects which need environmental clearance. Considering recent developments and to ensure that the economic growth and development in our country is in conformity with regulations for environmental conservation, the ministry has notified this. The environmental clearance process under implementation prior to 2006 highlighted the need to reduce specific processes, categories, activities, and also the need for new sectors such as coal washeries to be brought in the ambit of environmental clearance process because such kind of things had larger environmental impact. So, EIA notification 2006 has notified 39 development sectors which require prior EC. We further see that ministry has prepared EIA guidelines on each sector as identified by EIA notification 2006, which elaborates the procedure and mandatory requirements of EIA with respect to each sector. Further, notification sets the requirement for prior environmental clearance. It sets list of projects and activities that shall require prior environmental clearance from the central government in the Ministry of Environment, Forest and Climate Change. For matters falling under category A in the schedule, as per the list, the matters which fall under category A are required to get clearance from central government. Further, the projects and activities falling under category B require to take approval from the State Environmental Impact Assessment Authority. It also provides the procedure for EIA such as stages of screening, scoping, public consultation and appraisal. So, you see how the EIA Act of 2006 makes provision for the process for which projects have to be considered and how it has to be processed. Now, let us briefly look into Comprehensive Environmental Protection Index, CEPI. Looking at this Comprehensive Environmental Protection Index, CEPI, we see that CEPI is a rational number to characterize the quality of environment at a given industrial area following the algorithms of source, pathways and receptor. CPCB Center for Pollution Control Board, evaluated comprehensive environmental pollution index of 100 polluted industrial areas on environmental quality monitoring, which was conducted in 2018 as per the report of 2021 of MOEFCC. So, this environmental pollution index of air, water and land are evaluated based on presence of toxins, industrial activity, level of pollution, health statistic and adequacy of waste management facilities. If we look at slide categorization based on the range they do, we see that overall index score are calculated from the EPI score, and if score exceeds 70 in the scale of 0 to 100, then the industrial cluster is categorized as critically polluted area. And if score is 60 and above and it's less than 70, the industrial cluster is categorized as severely polluted area. So, we see two categories, critically polluted areas and severely polluted areas. In the list here, you can see that Brenihat in Assam, in Siltara industrial area in Raipur, Chhattisgarh, you can see Nazafgarh drain basin including Anand, Parbhat, Narayana, Okhla, Wazipur, all in Delhi, Ankleshwar, Vapi, Rajkot, Surat, Vatwa, Vadodara in Gujarat, you can see they all are categorized under critically polluted areas. Likewise, we see, I am just picking up some of the examples here, Vijayawada in Andhra Pradesh, Hajipur in Bihar, they are categorized under severely polluted areas. So, looking at this index is actually used as a warning tool and to formulate appropriate action plan to restore environmental quality within as per the norms. So, we see that this particular index also has its implication on the EIA process. Like any project or activity specified in category B1, which as per the procedure is reviewed by the state level authority for EIA, if it falls under the critically polluted area or severely polluted area, will be appraised by the central level. If it is located part or incomplete within the 5 kilometers from these boundaries of critically polluted areas or severely polluted areas. Now, moving forward, we are going to look at some of the environmental quality concerns and how different institutions are taking care of it. The concern for environmental quality has become the topmost issue in the present scenario of rising population, increasing urbanization, industrial pollution, shipping, aviation and vehicular emissions. So, you have experienced all that, we have discussed in our initial class. So, in order to address that, based on what I read through the annual report of MOEFCC 2021, we see that to give effect to various measures and policies for pollution control, various steps have been initiated, which include like stringent regulations, development of environmental standards and periodical revisions of their those standards, as well as control of vehicular, control on industry, air, noise and also taking care of the water pollution. So, now if you will see, the ministry's emphasis is more on the pollution prevention rather than end of the pipe treatment. This has led to initiatives for identification of best available and practicable technologies as the key elements for pollution prevention. So, it is better to prevent than to really treat it at the later point. The focus of various program and schemes of the ministry and its associated organization is on promotion of clean and low waste technologies. We also look at the waste minimization, reuse or recycling, improvement of water quality, nationwide monitoring of air quality, environmental audit, development of mass-based standards, institutional and human resource development and so on. So, we see such kind of initiatives. Further narrowing it down, if I would like to just name some of them, in the case of strategies, particularly sustainable strategies in the urban planning, we see that regional planning is seen as one of the approach to address this. Also compact city, high density development, so we have discussed on these as well, and then also focusing on redevelopment, redensification, creation of open space, also looking at energy efficiency by employing non-conventional as well as renewable energy sources. Further, we see energy efficient design like looking at building performance certificate and rating system, as well as handling the urban transport issues like transit oriented development, then also looking at strengthening of public transport system, reducing fuel consumption per passenger, road passenger with urban transportation system, non-motorized transport NMT, and intelligent transport system. So all these are strategies in the urban areas which we are looking at to address the environmental issues, environmental concerns. Also, we are looking at non-conventional source of energy and accessibility in the transport sector as well. Further, in the urban infrastructure segment, we see zero waste and waste recycling, GHG mitigation measures for wastewater, decentralized wastewater management, low water use and ecological sanitation, recovery of energy, reducing need for pumping. So, this all we have been, there have been a lot of interventions which are addressing this environmental concern in the area of urban infrastructure. Further, we see that with respect to climate change mitigation and adaptation, we have been working on green building, also developing index such as city biodiversity index. So the whole issue of pollution prevention and control is dealt with by a combination of command and control method, as well as voluntary regulations, fiscal measures, promotion of awareness, advancement of research in pollution abatement technologies, and so on. So looking at the items of work handled in control of pollution by the CPCB division, we see some of the interventions items of work include industrial pollution, waste, air and noise pollution, including marine pollution, common effluent treatment plant CETPs, Water Prevention and Control of Pollution Act 1974, Air Prevention and Control of Pollution Act of 1981, Taj Trapezium Zone TTZ, recognition of private laboratories under Environmental Protection Act 1986. Then we also see air pollution, noise pollution, appeals under Air Act, formulation and review of environmental standards, and so on you can see. And we have already looked into the Comprehensive Environmental Protection Index, which is also another item looked into by CPCB. So moving forward, further we see that Ministry of Environment, Forest and Climate Change has published the Draft Environmental Impact Assessment Notification 2020 with the intention of replacing the existing EIA notification of 2006 under the Environmental Protection Act of 1986. The key proposal of 2020 draft include like a reduction in time for public hearing, further exemptions of projects. You may look at notification and also aligned review with it. That all are suggested in the readings given here. Moving forward, we are going to look at the ministry's guidelines for eco-sensitive zones around the protected areas. Referring from URDPFI guidelines, Wildlife Protection Act 1972. Wildlife Protection Act 1972 gave provision for creation of national parks, sanctuaries and closed area. The purpose of buffers around these protected areas is to provide them as a shock absorber and based on that, ecosensitive zones were declared. So, ecosensitive zones would also act as transition zone from areas of high protection to areas involving lesser protection. The activities in the ecosensitive zones are regulatory in nature rather than prohibitive nature. You may look for details for the buffer and regulations for identified activities in the zone. You may refer to URDPFI guidelines table 7.2 for this purpose. So, this provides guidelines for declaration of ecosensitive zones. How do we really identify which are the ecosensitive zones? Many of the protected areas have undergone tremendous development in close vicinity of the national park, such as Gwandi National Park in Tamil Nadu, Sanjay Gandhi National Park in Maharashtra. So, the width of ecosensitive zone and type of regulations differ from protected area to protected area. But general principle is that the width of the ecosensitive zone could be up to 10 kilometers around the protected area as per the Wildlife Conservation Strategy of 2002. Now, let us look at the Coastal Regulation Zone. The central government declared certain areas as Coastal Regulation Zone CRZ and imposed restrictions on the setting up and expansion of industries, operations or process and like in the CRZ through the Coastal Regulation Zone Notification 2011. In this, the prime objective was to ensure livelihood security to fishing and other local communities living in coastal areas and to conserve, protect coastal stretches while also promoting development based on scientific principles. The CRZ notification was issued in 1991. This notification was superseded by CRZ notification of 2011, and then we see further that draft Coastal Regulation Zone notification is available of 2018 now. The said notification covers categorization of CRZ areas, permissible and prohibited activities, regulation of permissible activities in CRZ areas, procedure for clearance, preparation of coastal zone management plan, mapping an area requiring special consideration and so on. So, these all are covered under this notification. So, the coastal area of seas, bays, creeks, rivers and backwaters which get influenced by tides up to 500 meter from the high tide line and the land between the low tide line and the high tide line have been declared as Coastal Regulation Zone in 1991. The Coastal Regulation Zone have been declared by Ministry of Environment, Forest and Climate Change under the Environmental Protection Act 1986, while the CRZ rules are made by Union Government Ministry. Implementation is to be ensured by the state governments through their coastal zone management authorities. So, rules are made by the central government and then the state government ensures its implementation. Briefly looking into the definition of high tide, low tide and spring tide as per the CRZ. Looking at the importance of regulation of the coastal zone. So, why is it really important to regulate the zones? Coastal regulation zones are important for the protection of ecologically sensitive areas like mangroves, coral reefs, which act as a shield against tsunami and cyclone, improving the lives of the coastal communities like fishing communities, resilient measures for mitigating impact of climate change and high intensity cyclones. They are important to balance development with conservation of the coastal areas. In India, the Coastal Regulation Zone rules govern human and industrial activity close to the coastline in order to protect the fragile ecosystem near the sea. So, the kind of activities they restrict is like large construction, setting up of new industries, storage or disposal of hazardous material, mining, reclamation and bunding. So, these restricted activities are mentioned. We will look into zones to have little understanding of different categories here. So, we see that the zones are classified into CRZ 1, 2, 3 and 4. We see CRZ constitutes the ecologically sensitive areas and the geomorphological features which play a role in the maintaining the integrity of the coast. We see that coastal regulation zone 1 constitutes the ecological sensitive areas and the geomorphological features which play a role in maintaining the integrity of the coast. We see the CRZ 1B is the intertidal zone. The area between low tide line and high tide line constitutes CRZ 1B. Likewise, we see that there is CRZ2 which constitute the developed land area to or close the shoreline with the existing municipal limits or in the other existing legal designated urban areas or any habitation which are substantially built up with the ratio of built up plots to that of the total plots being more than 50%. So, we see that these come under CRZ2. Furthermore, we see that land areas that are relatively undisturbed and do not fall under the CRZ2, they constitute CRZ3. You may look at the sub-classifications provided here. Land area up to 50 meters from the high tide line or the width of the creek, whichever is less along the tidal influenced water bodies, are also earmarked as the NDZ in the CRZ3 areas, and these shall not be applicable where areas fall within the notified port limits. Further, we see that CRZ4 constitute the water area and are further classified, as you may make note of it. We further see that CRZ4 constitute the water area and is also further classified, as you may note here. We further see that the Act provides specific procedure that has to be adopted for obtaining project clearance, including rapid environmental impact assessment, disaster management report and risk management report, CRZ maps indicating the different lines, no objection certificates from CEIPI and then other related stuff here. We see that this notification also points out certain ecologically sensitive areas which are given specific consideration under the CRZ. So, we say that there are critically vulnerable coastal areas which include, for example, which are the list is given here. You have Sundarban region of West Bengal and other ecologically sensitive areas identified as under Environmental Protection Act, such as Gulf of Khambat and Gulf of Kutch in Gujarat and so on. So, this list is provided to you. Further, we see that special consideration is also given to inland backwaters island and islands along the mainland coast. Also, areas falling within the municipal limits of Greater Mumbai. So, these all are identified as areas requiring special consideration. Moving forward, we also find e-waste management rules of 2016. The e-waste management in India is registered under the Environmental Protection Act of 1986 with the objective of taking all steps required to ensure that e-waste is managed in a manner which shall protect health and environment against any adverse effect which may result from such e-waste. So, there is a lot of e-waste which we generated in current times. Moving forward, we also see interventions on mainstreaming urban river management into master plans. Seeing that cities and rivers have an intrinsic relationship, traditionally the rivers have been at the center of various cultural, regional, livelihood related and recreational avenues in cities. However, over the years, in the pursuit of economic development, cities have exploited rivers indiscriminately. Today, many of our rivers, as per the report, is in highly vulnerable condition. So, the document Mainstreaming Urban River Management into Master Plan is a guide to help city planning authorities in mainstreaming urban river management practices into their existing master plans. or while preparation of their upcoming plans. So, it guides them, guides the authority. Further, Urban River Management Plan, jointly prepared by National Mission for Clean Ganga and NIUA, provides a framework for all river cities in the Ganga River Basin. Looking at the overall objective of this document, we see that the intention of this document is to assist cities along the Ganga River to improve the state of the river in their stretch. And while the central focus is on Ganga, the document also applies to other rivers flowing through these cities. Now, we look at strategic plan for new and renewable energy sector for the period 2011-17, Ministry of New Renewable Energy. As per the URDPFI guidelines statement, India's substantial and sustained economic growth is placing enormous demand on its energy resources. The demand and supply imbalance in energy source is pervasive, requiring serious efforts by Government of India to augment energy supply. So, we are in a very critical situation where we really need to work on the energy component. So, India imports about 80% of its oil. There is a threat for its increasing further, so creating serious problem for India's future energy security. So, the vision of Ministry of New and Renewable Energy is to upscale and mainstream the use of new and renewable energy sources and advancing the national aim of energy security and energy independence with like attendant positive impact on local, national and global environment. You may further look into Smart City and Amrut document for funding sources and conversion provision for energy. Moving on, we will quickly look into the Indian Forest Act. The Imperial Forest Department, set up in 1864, attempted to establish British control over forest by various legislations. The Indian Forest Act of 1865 empowered the British government to declare any land covered with trees as a government forest and makes rules to manage it. By the Forest Act of 1878, the British administration acquired the sovereignty of all wasteland, which by definition included forest. So, as a result, the Act enabled the administration to demarcate reserved and protected forests. The local rights were refused in case of protected forest, while same privileges which were given to the local people by the government, which can be taken away any time. This act classified the forest into three categories, that is reserved forest, protected forest and village forest. It attempted to regulate the collection of forest produce by the forest dwellers, and some activities declared as offences and imprisonment and fines were imposed in this policy to establish the state control over forest. So, India's Forest Act of 1927 aimed to regulate the movement of forest produce and like duty liable forest produce. It also explains the procedure to be followed by declaring an area as reserved forest, protected forest or village forest. This act has detailed of what a forest offence is, what are the act prohibited inside a reserved forest, and penalties which are liable on violation of the provision of the act. So, observations indicate that many of the village communities were alienated from their age-old symbiotic association with the forest. It was basically enacted to make forest laws more effective and to improve the previous forest law. So, we see types of forests. You can see here reserved forest. Reserved forests are the most restrictive forest. Then you see another type is protected forest, in which the government has the proprietary rights and the power to issue rules regarding the use of such forest. Then we see village forest. You may take note of this. Village forests are the one in which the state government may assign to any village community the rights of government to or over any land which has been constituted as a reserved forest. And if you look at the degree of protection, so reserved forest is highly protected. Then you have protected forest, and then village forest, which has less governmental protection. Further acts we see are like Indian Forest Policy 1952, Forest Conservation Act 1980, then we see Act in 1988. 1988, particularly National Forest Policy Act, provided strong and significant basis for joint forest management. Moving forward, we see certain environmental guidelines. So we have environmental guidelines for industries, so that can be referred while making plans. This guideline for industry provides area to be avoided, and it also provides siting criteria. Then you have guidelines for rainwater harvesting, you have guidelines for buffer zones. So various kind of buffer zones related with eco-sensitive zone, industrial area and so on are available. So you also see environmental guidelines for planning eco-fragile zones such as coastal area, eco-sensitive zone, water bodies in urban areas, desert areas, wetlands and hilly areas. So for those, all environmental guidelines are available. Moving on, we see that there is also guideline for disaster management by NDMA with respect to flood management, earthquake management, drought management, cyclone management, tsunami management, landslides, snow avalanches management, even for urban flood management. And the guidelines also includes man-made disaster such as chemical, terrorism disaster, then also nuclear and radiological disaster and fire disaster and so on. So we find the section 23 of the Disaster Management Act 2005 states that there shall be disaster management plan for every state. So every state is required to prepare a disaster management plan, as well as we see that every district is required to make a district disaster management plan under this provision of same Act of 2005. We find other legal and regulatory framework as well. So entire list is provided to you with respect to water, air, forest and wildlife in general, and then hazardous waste. And then we also see that international agreements also are there on environmental issues, such as UN Framework Convention on Climate Change and then Convention on Biological Diversity. So these all act as a reference for us how to abide by it at the national and international level. Summarizing here, so this was all about the rules and regulations which are there. It was in a very brief manner brought to you. So here we see that today we studied about Environmental Protection Act. We also looked at National Environmental Policy. We looked at EIA notification. Then also very briefly touched upon Comprehensive Environmental Protection Index, then also looked at environmental quality concerns, eco-sensitive zones, coastal regulation zones, as well as e-waste management rules, then how we are looking at mainstreaming urban river management and mainstreaming it into master plan, as well as guideline for urban river management. Then we looked into the plan for new and renewable energy, as well as we looked into Forest Act, as well as we listed environmental guidelines which are available for planners, and as well as disaster management guidelines by NDMA, and then we listed legal and regulatory framework for environmental protection in India. These were the references. Our coverage was limited with the scope to make you aware of the topic. There are enormous readings and movies available to explore. Few are suggested here. This is not an extensive list. You may feel free to suggest more from your experience. Please feel free to ask questions. Let us know about your concerns you have. Do share your opinion, experiences, and suggestions. Looking forward to interacting and co-learning with you while exploring cities and urban planning. So that was all for today. Thank you.